So the practical impact of this case is that Oklahoma can, number one, go ahead and execute these 4 petitioners. The other practical impact is that states now have, I think, greater leeway in terms of the protocol they use to carry out lethal injections. I mean, the problem that from the state's perspective that the court addressed was that there was an evolution in the 3-drug protocol that Oklahoma had used. And the first protocol they used, which dated back to 1977, everyone agreed was constitutional. But what happened is people who were opposed to the death penalty had convinced pharmaceutical companies to stop supplying the drug for its use in executions. So then Oklahoma moved to a second 3-drug protocol. And then again, abolitionists were able to convince pharmaceutical companies not to provide that drug to Oklahoma. So then Oklahoma now moves to a third drug protocol in which the first drug is meant to anesthetize the condemned person. And then the next 2 drugs are essentially meant to paralyze and kill the person. And the problem from the prisoner's perspective was that they didn't have confidence and they thought there was a high risk that the first drug wouldn't work. And if the first drug didn't work, the person who's being executed would suffer extreme pain, essentially what everyone agreed would amount to torture because they wouldn't be actually free of pain while they were being paralyzed and essentially burned from the inside. One of the holdings of the court was if there's no other alternative, then the execution can go forward. I mean, Justice Alito starts from the premise that if the death penalty is constitutional, then there must be a constitutional way to carry it out. And of course, killing someone, Justice Alito says, for the majority, will always carry a risk of causing pain. Right? How can you kill someone without having a risk of causing pain? And so what he's focused on is there a substantial risk of unnecessary pain that is caused by carrying out the death penalty in this manner? Justice Sotomayor's dissent, in which she's joined by 3 of her colleagues, so we'll call it the principal dissent, takes issue with a number of Justice Alito's or the majority's propositions. So the first argument that Justice Sotomayor says is it's not the same to say that because the death penalty is constitutional, there must be some constitutional way to carry it out. After all, if the only method we had available to us, she says, is a method that's torturous, the Eighth Amendment on its own, which prohibits cruel and unusual punishment, should bar it. Her second disagreement with the majority's premise is on the existence of alternatives. So the majority says the reason the petitioners lose here is because there isn't an alternative way to carry out this execution. And Justice Sotomayor says, well, that doesn't really matter. After all, she says, the state isn't forced to execute someone, it's choosing to execute someone, and if the only way it can exercise that choice is through a means that causes torture, the Eighth Amendment should bar it. That's her argument. Justice Breyer's dissent, joined by Justice Ginsburg, is an invitation to advocates to fully brief the question before the court of the continued constitutionality of the death penalty on its face, not just when it's carried out in this particular method. And Justice Breyer's position, which he says is informed both by empirical studies of the death penalty and also his 20 years on the court, is that the death penalty is arbitrary, that it is inaccurate, that is, that there are lots of examples of people who've been condemned to die who later are shown to be exonerated. In fact, our own Innocence Project has been involved in many of those cases. And finally, that the death penalty is rarely used, in part because it takes so long for people to exhaust their appeals and other avenues for relief, such that there's just a long delay. Well, so I think we should continue to expect the issue to evolve, the issue of the constitutionality of the death penalty to evolve. There's, if we look at the trajectory of the last 20 years or 25 years of the death penalty, what we've seen is in one area, what the court has done is has restricted the use of the death penalty for certain crimes and also has restricted the use of the death penalty for certain kinds of offenders. And so there's been some movement by the court, this court, not just past courts, this particular court, to restrict the use of the death penalty. And I think we should continue to see that potentially changing over time.